Thank you for joining us today for our webinar, Returning to Work Strategies, Employment and Workplace Safety Implications of COVID-19. My name is Maciel. I am a chair of the Labor and Employment Practice Group here in Conn, Maciel, Carey, and a member of our COVID-19 task force. With me, I have my partner, Conn, and Aaron Gelb and Jordan Schwartz. And we are going to be going through, for the next 90 minutes, a myriad of issues relating to the return to work strategies and what you need to be thinking about when thinking about bringing your employees back to work if you haven't already done so. So the first half of the agenda today, we're going to talk about the employment aspects, and Jordan and I are going to be covering that. I'm going to start out talking about thinking about returning to work and flexible work arrangements, how you may need to modify your work schedules, and maybe if you haven't already implemented telework policies, to do so. And then other initial employment issues upon reopening. There's a lot of new laws that have come into play, a lot of new regulations, and so we want to make sure that everyone is thinking about those when you're bringing back your employees. And then Jordan's going to talk about wage and hour issues after reopening, and a lot of discussion has been raised recently about liability resulting from COVID-19 if there are tort claims as a result of the illness in the workplace. So that's hopefully the first 45 minutes or so, and then Eric and Aaron will cover the OSHA agenda.
Thanks for joining us today. This is Conn. I'm chair of the OSHA practice and coordinating closely with Carey on our firm's COVID-19 task force. I'm very pleased to join you all today to talk about the OSHA and workplace safety implications of coronavirus in the workplace. And here's a little agenda of what we'll get into in the latter half of the program today on those OSHA issues. We'll talk about OSHA's guidance, OSHA's and CDC's guidance about infection control in the workplace. And that has to be viewed sort of through the lens of OSHA's general duty clause. OSHA doesn't have a specific standard covering pandemics or viruses like this. So the idea that they've issued this guidance is essentially OSHA's cue for everybody as to what is expected of them to comply with their general duty obligations. So that discussion is about guidance, but it's also about what your enforcement expectations or what OSHA's expectations are about employers. And then we'll get into some of the specific topics and elements that we've been addressing quite often. A lot of questions about respiratory protection issues, both for required use respirators in light of the national shortage of masks and respirators, as well as how to handle voluntary respirator use requests. And then another big one is when, whether, and how to record COVID-19 cases involving your employees, as well as reporting potentially hospitalizations and deaths of employees associated with the virus. And then finally, a series of enforcement memos and guidance about how OSHA is enforcing both COVID-19 issues as well as non-COVID-19 issues where compliance is affected by the virus. So a lot of content today. Looking forward to the discussion.
Thanks, Eric. So as states begin to allow businesses to unlock your doors, there's a number of issues that you're going to need to be thinking about in order to get back into business and make sure that you don't run afoul of any local, state, or federal guidelines. These issues range from recalling and rehiring your employees, implementing flexible work arrangements, how to administer medical health screening exams, and complying, certainly with wage and hour laws. So the first thing we want to talk about are the importance of flexible work arrangements. It's going to take a while for businesses to come back for a variety of logistical and health reasons. We're in a new world, and still with the lack of testing and without a vaccine, you may still need to keep up with local social distancing mandates even after various government state restrictions are eased. And so you want to think about what you need to be doing to make sure that if you are bringing your employees back into your physical workplace, what you need to do to modify that work site to comply with social distancing. That could be anything from thinking of, general conference room, removing chairs around a conference table so that only a few people can sit and that they, are spread apart, or requiring employees to wear face coverings. We'll talk about that a little bit. If you are in a retail store and bringing people back, or a restaurant that's about to reopen, thinking about putting plexiglass in stores. I have a company in Oklahoma that's a casino, and they are reopening, and they are putting plexiglass in between the chairs of the slot tables. And so thinking about different things that you need to be doing, both from your customer perspective and their safety, but your employees' safety as well. Other ways to think about is also staggering work shifts. Maybe people are going to come up with different times, staggering when they come in, or days of the week that they want to work. So you may want to implement a shorter day week, a 4-10 hour week, or doing it at different times. And a big issue is you might want to make sure that you're attending to your employees' childcare needs. As schools remain closed for the rest of the year in most states, and then not knowing what the summer brings in terms of camps and other childcare needs, your employees will likely have childcare needs. And so you'll want to think about making sure you're attendant to them and what their schedules are, and maybe it may be helpful to have the staggered work shifts. The other thing we strongly think about and consider is, to the extent that you can do so, continue to allow your employees to telework if they've been doing so already. I think we're seeing a lot of companies really rethink about the need to have employees in the building. And if you have essential workers who can do their jobs from home and continue to work, that is really the best option for a while. And so it really is beneficial because it mitigates you having fewer employees in the workplace. Again, that staggered work schedule I just talked about. And it gives you an opportunity to test out some of these new health screening measures we're going to be talking about today, and safety precautions, so that you know that your return to work plan is working and that you can modify as appropriate, but you're not implementing your return to work plan with everybody back in the office at the same time. So if you do have people working from home, it helps continue that flow and continue to provide that teleworking arrangement, which might be in the best interest for everybody. One of the things that does that, it also shows your employees that you're doing everything you can to maintain a safe work environment. And I can't emphasize this point enough, and I think this is something that all of us are going to be talking about today, is really the importance of your communication message to your employees throughout this process. Your HR team, your senior leadership team, your management team should be constantly communicating with your employees, documenting what your return to work plan is, what steps you're taking to ensure that if they are coming back to work, you're implementing policies and procedures to ensure a safe environment, and all the other things that you'll be doing. And communicating to your employees is really important because it'll make them feel safer about coming back to work, and may avoid some of the other attendant issues that we've been seeing in the news recently, almost daily, about employees fearful about returning to work. There can be some unintended consequences for employees feeling like they are afraid to come to work. In a non-unionized environment, it quickly could lead to a union organizing campaign. So not the focus of today's seminar, but something I really wanted to emphasize at the outset is the importance of communicating your employees what you're doing to maintain a safe work environment so that they can come back to work and feel comfortable. If you have not already done so with your employees who are teleworking, you want to think about implementing a telework policy. And so what that does is it helps you manage the remote workforce and think about what your employees' expectations are and what their responsibilities are. Some of you who may have been forced to send your employees home in telework may not have had an opportunity to implement a telework policy with your employees, and you may have seen that some employees, are not working well from home. It's a new era, really, for people to be in front of their computer on Zoom all day long, or you know, and working and potentially with other people at home or children at home. And so it really, I think, helps to have a clear policy set in place that talks about some of these issues so that you're on board, your employees are on board. Talking about, you know, what are the expected work hours? Is this really a 9-to-5 job? And if it is, they are to be expected to be in front of their computer at, you know, from 9 to 5. And what happens when they don't show up to a Zoom conference until 10:30 and it looks like, you know, they haven't been working? So you want to think about that as well. You want to think about how they set up their workspace at home. Hopefully a lot of that has already been put into place over the last several weeks, but you want to make sure that whatever your policy is, it clearly sets out the expectations and responsibilities while telecommuting. The other thing for non-exempt employees is going to be really important on how they report their hours worked and making sure that they are abiding by your overtime policy to the extent that they're still able to telework. In different states, there are certain requirements for when non-exempt employees have to record their time. Some require daily reporting of time, some require reporting of when they take their lunch breaks. Jordan will talk a little bit later about some of the wage and hour issues, but I think that's really important to understand that this, we think, will be a onset of litigation in terms of wage and hour issues, whether you're telecommuting or having staggered work schedules upon the return to work. So think about the importance of a policy, and if you don't already have one, think about putting one in place with your teleworkers. I guess I'm talking about the wage and hour issues, so this is a good segue, right? So as I said, we really think that the rise in telework will result in wage and hour lawsuits over the next, you know, several months to a year, because it's not the same way that other people record their time. And so you may not be acclimating to tracking your non-exempt worker hours if they're not in the office. So you may have a sophisticated timekeeping system where someone can log in and, you know, and log into a software, and that should be no problem. Other companies may rely on a more, you know, typical time clock system where that's in the office and that might not be available at their home, or they use a sign-in sheet. So just be cognizant of the importance of making sure that your management team is appropriately tracking non-exempt hours, and ensure, to the extent that you're in a state that requires breaks, that they're not working through their breaks, or that you have a policy about breaks. Certainly we would expect that we could see that employees could claim that they were not paid for all hours worked in light of the fact that they don't have someone, their supervisor, directly monitoring and having eyes on the hours that they work. So now that we've kind of talked about things and teleworking, what happens once you start to bring people back and rehiring and recalling? So the first thing you'll think about is, all right, we just got a stay-at-home order lifted, or I'm in a state that I'm able to operate, or I think my state's going to reopen in 2 weeks. I want to start recalling my furloughed employees. Whether you have furloughed your employees or laid them off, or, you know, as a temporary layoff, however you styled it back in March, you need to think about what and how you're going to implement that recall. Unless you are an employer with a collective bargaining agreement that in a unionized setting, those CBAs have specific recall procedures, and you need to follow those CBAs to the letter in terms of recalling your employees. Usually it's by department, and within that department, it's usually by seniority. But if you're not a unionized employer, you really have a lot of flexibility on who to recall, when to recall, and the timing of that, so long as your recall decisions are not discriminatory. So be flexible. There may be some employees that you need back sooner than others based on the business needs. There may be, you know, some employees that you might not want to recall at all. And so you just want to be thinking about that. You do have that flexibility in a non-unionized setting. You also don't need to recall the employees to their same position or even at the same pay. I mean, you have the abilities to give that flexibility based on your business and operational needs. And I would imagine that most workplaces are in a different economic climate right now. And so you may not be in ability to pay someone that same rate of pay or even in the same position. But you make the offer of a recall, and if the employee chooses not to accept that job, then so be it. But you do have that flexibility if you need to modify the job that someone comes back to. And then this is a question that we've been getting almost daily, and I think we get it even more frequently. And that is what happens if you recall someone and they don't want to come back to work due to safety concerns? Now, let's just take this as an example of someone who, is a healthy worker and they just don't feel like they don't want to come back to work. This is where that communication message is really important. You want to have good policies and procedures and a plan in place to explain to them, well, here's all the reasons and all the things and steps we're doing and new procedures we're implementing to ensure that we are a safe work environment. So your concern should be alleviated. If it may be that you might be able to adjust someone's job, put them in a different department, isolate them in a different role, maybe, and bring them back. There may be some flexibility there. But generally, if someone is recalled and they generally don't want to come back to work for a variety of reasons, either a safety reason, or we're hearing a lot of reports that there's concerns that employees will not come back to work because they may be earning more money on unemployment, given the federal unemployment $600 a week extra stipend that they're getting. Many states have responded to that concern, and some states are instructing employers to notify the state agency if an employee is recalled and they don't want to come back to work. That is considered a voluntary resignation, and you can note that in your file and then leave it up to yourself whether you notify the state unemployment agency or not. But generally, if someone denies the recall rights, then they are considered voluntarily resigned, and generally they would not then be eligible for unemployment. Another thing on this last question in terms of providing new hire forms, different jurisdictions like DC, here in DC, I know New York has it as well. Some jurisdictions require you to provide a new hire form when you bring people back. If you're bringing someone back at a different rate of pay, at a reduced salary or a different hourly rate, those forms need to be recompleted and put them back in personnel file. If someone was laid off and now they're technically a rehire versus a sort of a furlough and who was stayed on your payroll, you might want to need to fill out that form again because it would be considered a new hire. So think about some of those initial instances when you're recalling someone back to work. And then importantly, you want to make sure that you're going through a process of balancing fairness towards all of your employees on the issues of health, as we just talked about. You want to make sure that you're doing it in a way that's not going to give rise to people claiming that you're doing it for discriminatory reasons. And so you want to be mindful of the way that you recall employees so that you don't fall into unintentional discrimination. For example, you don't want to only recall your younger workers who may also be your less expensive workers because that could lead to an age discrimination claim. So in the same analysis that you do when you do a mass layoff in terms of looking at the disparate impact of your workforce, you might want to think about that in your recall decisions. Are my recall decisions, if I'm not recalling everybody at once, would they have a disparate impact on a protected category of employees, whether that's age, whether that's race, whether that's gender, and make sure that you have a good, strong, rational basis for your rehiring decisions, as that is key to guarding against bias claims. This decision, like all decisions in the employment context, has to be based on legitimate and non-discriminatory reasons. So if you choose, however you choose to do your recall selections, make sure you document that. And you want to make clear that this is the reason why I'm recalling certain employees over others. Again, maybe it's because you have, you're a country club and the golf courses just got open today. in Maryland, and tennis courts. And so you can bring back that segment of your workforce, but maybe not other segments of your workforce. So just making sure that you have transparency and good documentation is going to be really important to ensuring that any claim later on down the road has no merit and you have a really strong, valid defense. The other thing we've been hearing a lot about is the idea that workers with medical conditions that make them more susceptible to COVID are reluctant to return to work. And the EEOC recently updated its frequently asked questions and said that employers really should be creative and flexible in the way that they try and provide accommodations to employees who have medical conditions. They refer to the number of medical conditions that are considered high risk by the CDC, and there's a handful of them. And if an employee has one of those medical conditions and says, I don't want to come back to work right away because I have this medical condition, you have the right to ask them to submit medical documentation of the medical condition and to request an accommodation. And you go through that interactive dialogue process with them to say what is the accommodation that they want. It may be that they want additional leave, or maybe it's they want to be put in a different setting, or maybe again a different department or isolated, or that they're given some tools in the workplace to help them with their condition. Could be a face covering. I know we'll talk about that in a little bit later, but there may be different types of accommodations that you can provide in making sure that you bring that employee back to work. And again, you're addressing their safety concern. You know, it might be an option where you allow that employee to continue to work remotely or telecommute. So just like with any ADA interactive dialogue process, you want to make sure it's documented and that you're really engaging in creative and flexible accommodation approaches. I think that will really be where the EEOC is looking at that. Importantly, the CDC's list of medical conditions, pregnancy is not one of them. So if you have an employee who is pregnant and says, I'm reluctant to return to work because I'm pregnant and I'm fearful that I might be more susceptible to COVID-19, that is one where you'd want to think about whether there is a separate duty to accommodate a pregnant employee based on your local jurisdiction. Otherwise, generally, it is not a disability under the ADA, and that is not something you would necessarily need to accommodate. But again, this might be a situation where your creativity and your flexibility might reign the day. So let's talk for employers that are maybe coming back to work that who have been out of work since April 1st. If maybe your business has been entirely shut down because you're a non-essential business and now you're able to reopen, I want you to be aware that there is a new federal law called the Families First Coronavirus Response Act that applies to small businesses. So you should really familiarize yourself with the FFCRA if you have not been open yet and you haven't had these leave rights for your employees, because we really think this is going to be a very tricky issue throughout the year, and we're already starting to see some legal claims brought as a result of it. So just very briefly, this law includes a new paid sick and family leave provision to employers with fewer than 500 employees. If you have 50 or fewer employees and are in the healthcare setting, you may be exempt from the paid family leave in certain circumstances. So the paid sick leave law allows employees to get paid sick leave for 6 qualifying reasons, and we've listed them here, generally all related to COVID-19, medical issues, or caring for a family member with COVID, or caring for a child whose school or daycare is closed, which we're seeing that across the country. Full-time employees are entitled to up to 80 hours of paid sick leave, and part-time employees are entitled to the average number of hours that they've worked over a 2-week period. And importantly, there's a difference in the employee's rate of paid sick leave depending on the reason for the leave. So employees who go on paid sick leave for the first 3 reasons on this bullet point, they must be paid at their regular rate of pay which shall not exceed $511 per day, which is $5,000, a little over $5,000 in the aggregate. Whereas employees who take paid sick leave for the last three reasons, caring for family members or a child or any other similar conditions, they are paid at a rate 2/3 their regular rate of pay, which shall not exceed $200 per day. So it's really important that you understand the reason for the leave and properly apply the rate of pay. Notably, the law does not preempt existing state and local paid sick leave requirements. So if you're in a state or a local jurisdiction that does have paid sick leave, and some jurisdictions have created more expanded paid sick leave recently, you want to make sure that this paid sick leave is in addition to the existing state and local paid sick leave requirements that you may have. The second part of the FFCRA are the paid family leave benefits. This provides for 12 weeks of paid family leave. The first 10 days can be unpaid, although the employees must be permitted to use the other paid leave during that time, including the 2 weeks of paid sick leave that I just talked about if they choose. Employees are eligible for this leave if they have worked for you for at least 30 calendar days. The paid sick leave applies to all employees, not just employees who've worked for you for 30 days, but the family leave is for your at least employees who have worked for 30 calendar days. After the first 10 days, you have to compensate your employees at a rate of at least 2/3 regular rate, kind of similar, as I said, for that paid sick leave if you're taking care of a child. And the use of this leave is again to care for a child whose school or daycare is closed due to COVID-19. There are some exposures if you deny time off to eligible workers or miscalculate their rate of pay or somehow, engage in any type of retaliation for an employee who has requested leave. And believe it or not, this law has been in effect for barely a month, and we have already seen lawsuits filed in federal court. There was a case filed in Pennsylvania against Eastern Airlines by an employee who claimed she was fired for trying to take time off, asking for leave due to her child's school being closed. And so you want to be mindful of this and make sure that your management team and your HR team are knowledgeable about this and actively engage with your employees who are asking for this type of leave rather than just outright deny it. The last thing I want to mention before I turn this over to Jordan is to talk about there is a posting requirement which you can get from the Department of Labor's website. You can circulate this by email, which electronic distribution is appropriate. But the good news is that if you will qualify for a dollar-for-dollar reimbursement through tax credits for all wages paid under paid sick or paid family leave law. So there is at least a silver lining on the new law that you should be able to get a dollar-for-dollar reimbursement through tax credits. So it's important that you closely track when employees use paid leave so that you can apply for that tax deduction. And with that, I'm going to turn it over to Jordan to cover new laws and procedures that are impacting employers.
Great, thank you very much, Kara. And it's nice to speak to everyone who's on this webinar today. As Kara mentioned, she just went through some of the wage and hour laws, the FFCRA, and now I'm going to start talking about new procedures that have been affected with COVID-19. Right away, I'll go into health screening procedures, and this is just such a distinct change from anything we've seen before. If this was a few months ago, and an employer asked me if I recommended taking employees' temperatures or doing other sorts of tests, I would certainly advise against that. Due to the Americans with Disabilities Act, which for the most part prohibits medical examinations or disability-related inquiries. But all of that, started changing when this became a pandemic, and such, medical examinations or inquiries, became somewhat job related and or consistent with business necessity. I actually saw on the chat just a minute ago, someone asked if they need to, as an employer, if you need to take these tests, or if you took them in the past few weeks, if you need to continue. And there's certainly nothing in the law that requires an employer to take temperature checks of all their employees and or perform COVID-19 tests, which some of our clients are doing. But what the law says right now is that you are permitted to take these tests, as long as you follow certain laws and procedures. As I mentioned, the testing in some way must be job related and consistent with business necessity. And just by having a healthy workforce in terms of this pandemic, I think we meet that. Also, I'll talk about it in a minute on the next slide. Another permissible reason for such procedures is through the direct threat exemption to the ADA. But before I get to that, there's just a few other points I want to mention. Employers really need to do their best to ensure that the tests are accurate and reliable. And for that reason, it may make sense to employ some type of vendor or use as an independent contractor, some type of vendor who is a qualified health worker to conduct the tests. That could just kind of help have it be someone who's more of an expert in this field than just the assistant manager who otherwise it may not be qualified to perform these tests. Employers also should still require that employees observe all other infection control practices. Just because you administer this test and let's say you do a COVID-19 test and all the employees come back negative, that doesn't mean that you need to ignore social distancing requirements or anything of that nature. You still need to be adhering to all the relevant rules and requirements that the CDC and other applicable health policy is dictating right now. And in terms of record keeping, employers who do test and record, most importantly, must keep the records confidential. You cannot, if someone has a high temperature, or even if someone tests positive for COVID-19, it's not a public record that everyone else needs to know. There certainly are steps we'll have to take, as I'll get into in further slides, but confidentiality is important, and the records should be kept for 1 year per EEOC guidance.
Jordan, can I just real briefly weigh in on the potential for additional record retention requirements under the OSHA Act?
Yeah, certainly. Go ahead.
This is a matter of some dispute among members of the OSHA Defense Bar and from OSHA itself, that there are certain types of records that if they are characterized as employee medical records under OSHA's regulation 1910-1020, there is a requirement to preserve employee medical records for 30 years. I dispute whether these records would actually be employee medical records covered by that regulation, because the regulation uses very plain language. It says that the record, an employee medical record is a record made by a medical professional. So if you have your plant manager, HR manager, or a supervisor who's doing the temperature screening and writing down the temperatures, it is my opinion that that is not an employee medical record covered by 1020, but I know that other OSHA attorneys have said that it is such a record, and OSHA apparently has said some inconsistent things about that lately as well. Our general recommendation for that reason is that if you are implementing a temperature screening protocol, do that, but don't record the actual temperatures, right? We're not taking this to track trends or anything like that. We're taking it to determine whether there is a potential for bringing a sick employee into the workplace. So if you're recording anything, I think it's a check or an X, or permitted to enter, something like that, but not actually writing down the temperature, because if there is, there's at the very least a requirement to retain it under the ADA for at least 1 year, and quite possibly a requirement to keep it for 30 years, or possibly running into a dispute with OSHA whether you should have been keeping it for 30 years, which I don't think you're actually required to do, but best not to record it if you don't have to.
Great, thank you very much, Eric. Moving on to the next slide, just a little bit more from the employment perspective here for these health screening procedures. And again, whether we're talking about a temperature check or a COVID-19 test or another medical exam related to COVID-19, employers can require employees to participate in testing even if they do not exhibit symptoms. You can have a workplace policy now, institute a rule that all employees are required to test. If someone has a legitimate disability-related reason why they can't, then we'll have to engage in the interactive process. But for now, the default can be that you require all employees to undergo testing. And as I mentioned earlier, this is also permissible under the direct threat exemption of the ADA. And just so you know what that is, the ADA defines a direct threat as a significant risk of substantial harm to the health or safety of that employee or others, which cannot be eliminated or reduced by a reasonable accommodation. And this is intended to shield employers from liability who have to take an employee's potential disability into account in order to protect employees from danger. In the past, we thought of this more with, let's say, an employee who had uncontrolled epilepsy and frequent seizures. So that employee might not be able to safely operate heavy machinery. But of course, that is now applicable here, where if an employee potentially has COVID-19, that could present a danger to all other employees at the workplace. So the direct threat exemption kind of gets the employer to feel confident that they can engage in these tests. Again, I think I mentioned this already, but I just want to continue to emphasize that a negative test does not mean an employee will not be infected later. So employers just need to keep on following the guidance of the CDC, the FDA, other medical and public health authorities. And it's not just, of course, a one-time deal that the employee is negative and then we're good to go. Another option, if an employer doesn't want to go through the, let's say, burden, for lack of a better word, of administering the tests, some companies do have employees self-monitor. They take their own temperature every day before they come to work, and they make sure they're in the proper range, or they fill out a questionnaire either every day or every few days that either the employer came up with or that some sort of vendor came up with that is related to medical conditions, but in that way the employees aren't undergoing tests while at the workplace. One is not necessarily better than the other, really. We have a whole host of people on this call right now from various different industries, and it really depends on your particular industry. But moving on to the next slide, at the end of the day, the few bullet points here I just want to lay out in terms of health screening procedures is, as with anything, the testing should be conducted in a non-discriminatory manner. Either all employees or all employees of a certain department. It's not recommended to pick and choose certain employees. Again, the confidentiality of the test results, as I mentioned. Kara had talked about some wage and hour concerns. I'm going to talk about some wage and hour concerns because that's always prevalent when you're speaking to employment attorneys. But An interesting issue is whether the time test that an employee is being tested is compensable under federal and state wage and hour laws. And there's not a one size fits all answer to that. Courts have come out different ways. And if you're just taking a temperature and it lasts a minute, you know, either way, it's kind of de minimis, so you don't need to worry about it. But if it's more than a minute, unless you're in a state that is fairly certain that time is not compensable, you know, we're for the most part recommending to our clients that you do pay the employees for that time. They are at the workplace, even if they're not actually performing work. They are doing something work related. That, you know, they're not just spending the time on their own. And you know, Carey had mentioned kind of employee morale issues during this difficult time. And you know, if nothing else, to tell employees you have to wait in line, you have to get tested, but we're not going to pay you for that time, even if that somehow doesn't violate wage and hour law. It's not great for employee morale. You know, certainly if employees refuse testing, and that will happen, you need to have some protocols in place so you know what to do. You may want to have consent and acknowledgement forms, you know, not necessarily a waiver, but something where an employee is acknowledging that they are taking a COVID-19 test. You need to establish a protocol for notifying employees of positive results if that happens. And then, you know, you need to determine when and under what conditions employees who test positive can return to work. I think the latest guide, CDC guidelines is, you know, once you're medically cleared after three more days after you have a negative test, you can return, or 3 days after you don't show any more symptoms, I believe is what the CDC is saying, or 10 days after you were tested positive, which also includes 3 days with no symptoms. But that type of advice, I even hesitate because this webinar is being recorded. That type of advice changes so frequently that you don't just want to rely on what someone said on May 7th, when on May 10th, the guidance could be different. So you need to keep on just being really active and cognizant in making sure you monitor the CDC's guidance about when it is permissible to have employees return to work. Moving on to the next slide, somewhat related to health screening, but you know, shifting a little bit. The title of this slide here is requiring employees to wear masks. And first, I want to point out I intentionally put masks in the title, you know, almost just as a shorthand, but I wanted to remind myself to speak to you all about that. In actuality, a mask typically is defined as, you know, either a filtrating respirator, such as an N95, or a specialized medical grade or surgical mask. At this point, both of those should be reserved for healthcare providers, first responders, and essential workers, you know, that are really need to fulfill OSHA and workplace safety requirements. If surgical masks in the future become more easily obtainable, then maybe employers will want to require employees to wear masks. But right now, I'm actually focusing on face coverings. I know it's just a potentially you think that's a minor distinction, but I just want to be clear that the next few slides, I'm actually talking about face coverings, not these medical masks. And as with the health screening, I am not saying that you need to require employees to wear masks. Again, it depends on your industry and depends on your workplace and maybe the state in which you operate. But what I am telling you is that as an employer, you may require use of face coverings in the workplace. And you know, a face covering is just some type of cloth that, or even another material, but it's usually cloth that covers an employee's mouth and nose. And the 5 criteria the CDC lists for face coverings are that it fits snugly but comfortably against the side of the face, be secured with ties or ear loops, include multiple layers of fabric, allow for breathing without restriction, and be able to be laundered and machine dried without damage or change to shape. Moving on to the next slide.
Jordan,
Basically,
can I chime in real quickly here as well? Because this is
sure.
An issue where there's real overlap with OSHA regulatory issues and questions that we're getting a ton of on the OSHA side. And you did an excellent job of drawing that distinction between what is effectively a respirator, an N95 mask or something more substantial, even though it's called a mask and it looks like a mask, is actually considered to be a respirator by OSHA. And if you're permitting the use of a respirator, an N95 mask, even if you're not supplying, if an employee brings his or her own from home and you permit the use of that, there are regulatory requirements that kick in, like providing a copy of Appendix D of OSHA's respiratory protection standard and assessing whether the employee can safely wear a respirator mask without causing greater harm to themselves. If they have some obvious or apparent respiratory issues, you might not want to permit that voluntary use. Flipping over to the other kind of mask that Jordan, I think, very appropriately referred to as a face covering. That's what, in my mind, I've been trying to distinguish between respirators and face coverings, something less than what would be considered a respirator by OSHA. Those are certainly, as Jordan explained, you may require those to be used. One of the things that we've been assessing and answering a lot of questions about is that considered personal protective equipment, such that if, as an employer, I require it to be worn by my employees, I am covered by OSHA's PPE standards. That means I've got to pay for it. I've got to make sure that it is, being used properly and stored and cleaned if it's being reused more than once, and that I need to implement, a PPE policy or program as it relates to those face coverings. Our view is that if you are not talking about the robust kind of medical grade, NIOSH approved, FDA approved types of masks, and you are talking about something that is essentially just a face covering, like bandana, like a do-it-yourself, face covering, like the CDC has been putting out instructions, or any of these relatively loose-fitting face coverings, that is not personal protective equipment. It's important, it's helpful. The idea, though, is that it is not protecting the wearer as much as it is protecting people around the wearer from potential secretions by the wearer. And in that context, because it is not protecting the wearer of the face covering, it is not actually considered PPE by OSHA, but still a valuable infection control plan to include in your plans for opening your business, because the idea would be, my mask protects you, your mask protects me. If everyone's wearing it, it is an additional, I think, really important form of protection in the workplace. It's just not going to trigger those duties under the PPE standard, which means technically you're not required to pay for it or supply it. It would be like telling your employees they have to wear long sleeve shirts or no open-toed shoes. But if you're going to require it and it's going to be a big piece of your program, I think you ought to consider supplying it and paying for it just to make sure that it's being used consistently. But our view is it's not required by OSHA's PPE standard. So sorry to jump in there, but there's incredible amount of overlap between these employment issues and the OSHA issues throughout.
No, and that's a great distinction, Eric, because if you look at my next slide, I almost inadvertently stumbled upon an OSHA term of art that this distinction is important, because my first bullet point here was, what if you do require it and you distribute a face covering, but an employee fails to bring it to work? And what I meant to say is basically, because face coverings are considered important and protective, that was not supposed to be personal protective equipment. And it just says protective equipment. But I just want
that's how I characterize it as well, because I try to, it's not PPE, but it is protective. It's intended to protect the workplace. And so I think this is exactly right still. Okay,
great. So I just, want to, if you have a rule that you distribute it and an employee fails to bring it, they cannot, you can, you can enforce your rule that an employee is not permitted into the workplace until he or she is able to obtain their face covering. I'll get into some exceptions in a second, or reasonable accommodations in a second. But if you do distribute face coverings, but employees want to use their own, that might be okay. You just need to have someone to make sure that it seems to adhere to the CDC's requirements. As Eric mentioned, you may want to provide employees with a reimbursement or subsidy. It's not required, but it's just along the lines of trying to consider whether you want to do that and if that's helpful. Make sure though, of course, now there's so many different face coverings with, sometimes they have different sayings on them and things like that. And, again, as an employment lawyer, I need to advise you, make sure it's work appropriate and it doesn't have offensive language or images or anything of that nature. Moving on to the next slide, as an employer, if you are requiring face coverings, like many other new policies, you might have to do a little bit of training, on how to wear, maintain, and clean their face coverings. You might want to really inform your employees that they need to securely cover their noses and mouths. They shouldn't move, reverse, or remove their face coverings unnecessarily in the workplace, and they shouldn't share their face coverings with others. That might seem common sense, but better safe than sorry to provide this sort of training. And another overlap here that Eric may want to jump in. I'm not sure, but if there's single-use face coverings, you want to make sure from a workplace safety standpoint that the employees properly and safely discard the face coverings into the trash after each use. And if you're providing employees with single-use coverings, you want to make sure you have a sufficient supply. Employees may even need to replace them more than once a day. So those are just other issues that you may not have thought of a few weeks ago that you now need to keep in mind. If an employee declines to wear a face covering for medical reasons, and I've gotten a lot of questions about this the last week or two, you need to engage in the interactive process as required by the ADA. This is a real tricky situation because a lot of people don't like wearing face coverings. I don't like wearing face coverings, but this is not, you do not have to provide an accommodation to someone who doesn't like wearing face coverings. It is just if that individual has a medical issue, chronic obstructive pulmonary disease, claustrophobia, asthma, other similar conditions, you may need to think about what accommodation, if any, can be provided. There might not be an appropriate accommodation. Just letting someone not wear a mask when everyone else is wearing a mask might not be feasible, because then they're potentially risking all the other employees. But if that person can continue to telework, if they can work in an office by themselves or have almost no contact with others, if they can take more breaks, if they can work shorter hours, there may be some sort of accommodation that you may be able to provide. But at the end of the day, you might not be able to provide an accommodation, and then the employee may not be able to perform their essential duties otherwise. So that's really, really a tricky situation. And on the next slide, a similar situation is, what if an employee declines to wear a face covering for non-medical reasons? What if it's for a religious reason? And again, you got to engage in a similar interactive process, figure out if there's any sort of solution that can not discriminate against the employee, but adhere to these important safety concerns. Also, there's, I've read about a lot of bias concerns. People of color in certain organizations have been extremely concerned that their employers are requiring them to wear face coverings that don't really look like protective masks, and then they leave their place of employment, and then they are maybe wrongly suspected of criminal intent and activity. So that's just something else just to consider. You got to consider all these all these situations when you're deciding, you know, whether or not to require masks. And the last slide on this face covering and mask issue is that, you know, you want to keep the health concerns, of course, but also make sure that for whatever reason the face coverings do not interfere with your employee's ability to perform their job. But at the end of the day, if you've decided it does not interfere with an employee's ability to perform his or her job, and there isn't a valid medical or otherwise protected objection, it's possible that they should not be permitted to work, and that maybe they should be disciplined for not following work requirements. Now moving on, let's move on to wage and hour issues here, because eventually I want to leave time for Eric and Aaron to talk about OSHA issues. So we've already talked about a few wage and hour issues, but let's talk about specifically exempt and non-exempt issues. You may have some exempt employees, you know, some managers, assistant managers, you know, for those of you who don't know, exempt, you know, essentially salaried employees under the Fair Labor Standards Act, that now when you're bringing employees back, perhaps you're not bringing as many back, and some of your salaried, you know, managers or assistant managers are now spending time doing hourly work, you know, spending time as cashiers or doing whatever is needed, you know, kind of in an all hands on deck point of view. And under the FLSA, typically an employee is only exempt if their primary duty is performing duties that satisfy the exemption test. And, you know, primary duty, of course, means principal, main, or most important duty. And generally, an employee who spends about at least 50% of the time performing exempt duties will satisfy this test. But now, again, with kind of the new world order here and the new workplace situation, many exempt employees may be spending much more a percentage of their time not performing exempt duties. But that doesn't necessarily prevent an employee from continuing to be considered salaried or exempt. Courts will really look to a more holistic approach. So rather than just looking at each day or even a work week to see how many hours an employee spent performing exempt or non-exempt work, you want to look at kind of the main duties, the most important duties that the employee is performing. And you want to look at a period longer than one work week. And as I set forth in this next slide, you know, time spent performing the primary duty is not the only factor for meeting the duties test. So as long as the employee, you know, the relative importance of that employee's exempt duties is more important, his managerial duties are more important than his cashier duties, as long as he may be relatively free from direct supervision, or if he makes more money than another employee who would perform the let's say cashier type duties makes, all of those are indicators that this employee can continue to maintain his exempt status. And this is going to come up largely in the retail space, as well as the hospitality and the service industry. So it is, you know, this is important to keep in mind, but don't get bent out of shape if an employee is now, an employee who used to spend 30% of their time doing non-exempt duties is now spending 60% of his time. On the other hand, if an exempt employee comes back to the office and then is reassigned to a position that is not traditionally classified as exempt, then the employer should consider reclassifying the employee to it as a non-exempt employee. So just to avoid potential wage claims, as an employer, you should carefully review each employee's job duties and reevaluate their job classifications, especially if changes are being made to how the workplace is being managed. Another similar issue here, talking about different duties, is a calculation of an overtime rate for an employee. To sustain business operations and reduce costs the past month or two, if the employers who have retained employees, in addition to reductions in force and work and furloughs, have asked employees to perform work in 2 separate positions with different rates of pay. And that is permissible. You just need to make sure that if the employees work more than 40 hours a week and they are non-exempt, that they are being paid properly for their overtime rate. And the FLSA has its default rule that requires that the employee be paid 1.5 times the weighted average of the 2 different rates. So just keep in mind that employers must calculate this blended rate for every week for each employee, and that the employee's pay stub should reflect the hourly rate that the employee received working in each position. The blended rate should not be reflected as the employee's hourly rate for all hours worked. Rather, the hours worked in each task at the assigned rate should correlate, and then the blended rate should only be used for calculating the overtime rate. And with that being said, I just want to move on to the last topic that I'll just talk about for 2 minutes here before I turn it over to Eric and Aaron. And this is about liability resulting from COVID-19 claims in the workplace. And we get a lot of questions. We're about to reopen our doors and rehire our employees. What do we have to worry about in terms of tort liability? And historically, for the most part, if an employee gets injured on the job, or if an employee gets sick on the job, the employee is eligible for workers' compensation. While that is still the case with COVID-19, there is an exception to this that I want you all to be extremely aware of, and I don't want to say concerned about yet, but at least be fully aware of. And that is, the plaintiffs may want to try to bypass this workers' comp system in order to get a much more significant damages awards. So if they can attempt to determine that an employer is grossly negligent by failing to take steps to mitigate COVID-19 in the workplace, the employer really could be susceptible to actual tort liability. And moving on to the next slide, there's a case that's already been filed in Illinois State Court against Walmart. And what the case alleges is that store management was aware that several employees were exhibiting symptoms consistent with COVID-19, but that the store failed to follow the necessary health and safety guidelines. And as a result, the estate of one of the deceased employees is suing for negligence, willful and wanton misconduct, and similar state laws. The brunt of the allegation is that Walmart failed to exercise reasonable care in keeping the store in a safe and healthy environment, and in particular to protect employees, customers, and other individuals within the store from contracting coronavirus. In other words, they knew or should have known that the individuals at the store were at a very high risk of infection and exposure. And moving on to the next slide.
Jordan, can I add? Want to add a little bit to that discussion as well. Is we have seen historically, just really broadly in any kind of workplace hazard context, that plaintiffs' attorneys have used OSHA violations, particularly willful violations, as a means of trying to circumvent the workers' comp exclusivity bar, because most states have what's called an intentional conduct exemption to the workers' comp exclusivity. So if there was intentional misconduct, that can be a basis to set aside workers' comp and to be permitted to bring an action in tort, wrongful death or personal injury. Typically, those states require intentional harm as opposed to just intentional conduct, but you very often will see evidence of a willful OSHA violation as a way to try and get around that comp bar. And here, OSHA is going to be out there evaluating your response to this pandemic. If they believe your conduct, as Jordan described, is grossly negligent, if you knew that there were exposures, if you knew that there were measures that should have been taken that weren't taken, I would not be, terribly surprised in a serious outbreak situation to see OSHA bring something in the way of a willful OSHA violation. And then the other thing, maybe you're going to talk about this as well, is that there's others other than just your employees who may contract the illness, perhaps because of steps you did or did not take in your workplace. And if you're going to talk about that, I'll be quiet. Otherwise, you just know those folks are not limited by workers' comp. And that could be a guest, a customer, a patient who comes to your facility. They can sue you. They're not barred by workers' compensation. And then likewise, if an employee takes, gets sick at work, takes that home and spreads it through the rest of the family, that employee's family members are also not barred by the workers' comp exclusivity bar. And that's something that's pretty unusual, right? There's workplace hazards, but it's hard to take that hazard home with you. Well, this is a little bit different. So there's potential plaintiffs out there who would not be subject to that bar as well. Maybe that's what you're going to talk about here, but that was one of the big issues we're seeing in that OSHA context as well.
Right, and I'll just mention, one case I just read about the other day is a restaurant in Texas that is allegedly prohibiting its employees from wearing face coverings, and I could foresee a customer coming into the restaurant and potentially contracting the virus, and then suing the restaurant, because again, it's not an employee situation. It's that the customer might say, "Oh, you had staff that wasn't wearing a mask, and I thereby became infected, and I am suing you for negligence." So we don't know how that's going to play out yet, and what other precautions were in place and things of that nature. But all these decisions, if you are an employer or a company that also deals with the public, you have to, as Eric mentioned, be dealing with employee safety and public safety. I'll just finish here with this Walmart case and then turn it right back over to Eric. In Walmart, this was still in March. I don't think the CDC had officially promulgated the face covering guidance yet, but these 7 steps here are all the allegations that, the ways that the plaintiff alleged that Walmart failed to, acted negligently, failed to clean and sterilize the store, failed to implement social distancing guidelines, failed to provide proper PPE, failed to warn the plaintiff and other employees at the store that other employees were exhibiting COVID-19 symptoms, ignored employees who communicated to management that they were experiencing COVID-19 symptoms, failed to follow just general OSHA and CDC guidelines, and failed to train employees to implement and follow employee health and safety protection guidelines. So, there's just a host of ways that an employee can allege that you're not adhering to proper safety protocol. Hopefully, whatever you're doing won't amount in any way close to gross negligence, but you just really need to be careful. And then just generally on my last slide, if an employee does exhibit COVID-19 symptoms, the best thing you can do is just take immediate action as an employer and quarantine the employee immediately. do your best to identify all other employees who had contact with the infected employee, inform such employees of potential infection, and send COVID-19 positive employees home, or people who interacted with COVID-19 positive employees home until cleared by a medical professional. And I believe Kara mentioned this way at the beginning. Just, with all of this, it's best for employers to be transparent with their employees and actively engage with employees. In this case, I'm talking about those who are quarantined or who had tested positive. But I really kind of mean that to end my portion. I mean that more holistically and generally, and just keep them aware of what's going on in this space. And with that, I'll turn it back over to Eric.
Actually, Jordan, this is Aaron Gelb. I'm going to take the first portion of the OSHA slides. So nice to speak with everybody. I lead the firm's Midwest OSHA practice out of Chicago. And like Eric, we've been, and everyone at the firm on the task force, have been drinking from the fire hose fast and furious with coronavirus issues. As Eric said at the outset of the program on the OSHA side, that there is no specific infectious disease or pandemic standard. For those of you that have been tracking this issue in the news on the workplace safety side, you may have seen that there's been something of a dust up between unions, particularly the AFL-CIO and Secretary of Labor Scalia, unions and some workers' rights advocate groups taking the position that OSHA has essentially left the field. They've abdicated their role. I think that the term that was used, that there's no cop on the beat. And Secretary Scalia responded in what I thought was a very well written letter, completely denying that, ensuring the regulated community that OSHA is indeed patrolling the beat, taking efforts to conduct enforcement efforts and address issues as best they can. And I can certainly say unequivocally from my perspective, from the clients and the companies that we're working with, that OSHA is very much patrolling the beat. We've seen a constant flow of hazard alert letters that are coming in. So those responses are required when employee contacts an area office, speaks to an intake person, a duty officer, reports or shares any concerns that they have about the company's, their employer's response to the coronavirus. And the area office sends out a letter requiring a response within a certain period of time. Just from anecdotally, the conversations that I've had with area offices, both area directors, assistant area directors, and co-shows on inspections that I'm handling, is pretty much all that they are seeing day in and day out. And the volume, as you might imagine, since this is really the issue that is front and center with pretty much everybody right now, is extensive. One area director said that they had about 75 complaints come in over the weekend from when they shut down the office on Friday to when they came in on Monday. So we're seeing that. We're seeing formal fatality inspections being opened. We're seeing some inspections being opened when the agency believes that there is a cluster or unusual number of cases in a particular workplace. And just kind of as one example, you may know, you're able to search on OSHA's website inspections at a particular area office or of a particular company. And when I looked yesterday at one of the area offices here in Chicago, the first page that came up of open inspections, it shows 20 per page. 17 of the 20 inspections were fatality inspections. And although it doesn't state the nature of the fatality, it's quite apparent that they are COVID related. There were several nursing homes, there were several hospitals, and there were several manufacturing sites, including a couple of manufacturers that have been in the news because they shut down their facility. So the fact that OSHA is opening inspections and then we're seeing fairly detailed requests for documents and information certainly tells me that they are patrolling that beat, and they are enforcing this, or conducting enforcement as best that they can. But then back to the absence of a standard, a specific standard. OSHA is left to use the general duty clause for its enforcement efforts here. Many of you are probably familiar with the agency's use of the general duty clause in the context of heat stress, workplace violence, issues like that. So, how do they use that here with respect to COVID-19 or the coronavirus? There are essentially 4 elements that the agency has to prove in order to establish a violation of the general duty clause. They have to show that the hazard exists in the workplace, that the employer or its industry recognizes the hazard, that the hazard is likely to cause death or serious injury, and that feasible means exist to eliminate or reduce the hazard. I think it's fairly certain that the first 3 elements are likely to be satisfied. I don't think many people are going to dispute, or it will be difficult for an employer to establish that COVID-19 is not a hazard in the workplace, or certainly that it's not a recognized hazard, or that it's not likely to cause serious injury or death. So where the rubber meets the road, in essence, is going to be the feasibility of abatement measures that the employer can take. Jordan has talked about a number of those, and we'll get into some other ones. So moving on to the next slide. Besides enforcement, what else has OSHA been up to? They've been issuing a lot of guidance documents. Eric is going to talk about a number of different guidance documents dealing with kind of the relaxation or scaling back of enforcement on other issues. OSHA really kicked off its guidance issuance with a general and I don't want to say detailed, but long document on March 9th. It largely follows the CDC's guidance and divides the type of work or tasks performed in different workplaces into different risk exposure levels, and then ties with those exposure levels different recommended steps that employers should consider and possibly implement in their workplace. It's important to keep in mind that when you look at the date that this guidance was issued on March 9th, for me at least, that feels like years and years ago. So much has changed in the last 2 months. If you think about when this came out, I think I had just flown back from the ABA's OSHA committee meeting in California just 3 days before. I was somewhat certainly mindful of this growing concern, but I was on an airplane. I wasn't wearing a mask. No one was checking temperatures. So when you think about, this is the guide, put that guidance in the context in which it was issued, it's still helpful. It's certainly something that you want to look at and to consider as you're going forward and trying to develop a plan for your workplaces to protect your employees, to prevent transmission. But keep in mind the context in which it was issued. OSHA has since then been issuing other guidance documents, many of them dealing with specific industries, so guidance for retail, guidance for we've seen for meatpacking, guidance for various, I think, construction as well, and a number of other industries. I always commend and recommend the OSHA's website. It's a good source of information, at least a starting point, and you can find this guidance document and others on the website. Moving on to the next slide, as I said, within the March 9th guidance pamphlet, the agency has basically divided work tasks or positions by 4 different risk exposure levels. And the first 2, the very high and the high level, really focus on 2 industries, healthcare and death care. So if you're in those 2 industries, obviously the very high level are those who are involved positions that are actually caring for patients that are either confirmed positive or believed to be positive cases of COVID-19, morgue workers who are performing autopsies on known patients. And then in the high category would be people who are providing healthcare support, transport, workers, morgue workers, mortuary workers who are preparing bodies of either suspected COVID patients. So, and as you might imagine, there are a larger number, a greater extent of recommendations and suggestions that are included or tied to positions in those high to very high categories. The majority of the companies that I've been working with, and I think most of us have been working with, fall within the medium and lower risk categories. And what's important to keep in mind with respect to those categories, at least when I look at this issue, we're also considering your geography. So for many of the manufacturing clients that I work with would, if in a vacuum, probably fall within the lower category, the lower risk category, because these are people that are essentially working in essence a closed environment in that it's only the employees of that company. There are few, if any, outsiders, third parties that are coming into that workplace. But if that manufacturing facility sits in Chicago or in the New York metropolitan area or other areas that are experiencing high levels of community transmission, then I think that you likely need to bump that workplace up into the medium level category. Other employers that are seen in the medium category would be retailers, grocery stores, pharmacies, any workplaces where you're exposed to members of the public, individuals that you don't know and can't determine if they might be carriers of the virus. Moving on to the next slide, please. So as far as this slide deals with a number of the suggestions or possible protective measures to consider that are set forth in OSHA's guidance document. There are lots of suggestions in there. They aren't terribly specific, obviously, the nature of the publication being that it's aimed at largely the entire U.S. workforce. It covers suggestions for manufacturing, for healthcare, et cetera. So it's certainly, it can be a starting point, but it's not going to be your only resource. But a number of these ideas or concepts are particularly helpful and good, worth considering. If you look at this pyramid on the right-hand side here, this is again tied to the different categories of positions. And the more, again, the higher the risk, the more protections that you need to consider. For me, I think the starting point certainly is the development and implementation of a COVID-19 exposure control plan. This is really going to be your organizing document. If for those of you that have lockout tagout programs at your workplace, or respiratory protection programs, the program document includes all your elements. It's kind of the go-to source. So whether you're open and you have been open as an essential employer, or if you're planning to reopen in the coming weeks or months, if you don't have an exposure control plan, that should really be your first go-to, the first item on your list to make sure that you develop one. That's something certainly that we can help with. As I think Jordan used the word holistic. It is an approach that's going to involve, it should involve a variety of stakeholders within your workplace to help develop and consider all the different aspects.
Aaron, one thing I would add about the exposure control plan, our recommendation is you put together this written document that is the control and response plan. It's going to include everything on the bullets that follow. The reason why you pull it all together in one good document like that is it's going to serve three constituencies. One is your employees are afraid. There's a lot of anxiety out there, and that's why, as Aaron described, there are really thousands of employee complaints to OSHA about, my employer is not providing protective equipment, my employer is not implementing CDC recommendations. I have no idea what my employer is doing. Having a thoughtful written plan that pulls together all the actions you're taking will hopefully help ease some of the anxiety of your employees so they're not complaining to OSHA. And then the other is, if they do complain to OSHA, OSHA is going to come to you and ask for, how are you responding to this? What have you been doing to deal with the pandemic? And how are you responding to this particular allegation the employee has made? Having that written plan is a great thing to share with OSHA to say, hey, look, we're on top of this thing. We're implementing all of yours, OSHA's, and CDC's guidance and here it is in one neat, tidy plan. So that's a good way to deal with the issue. So didn't mean to interrupt there, but that's another reason why you have that kind of umbrella plan.
Right, and it is a good, effective way to communicate that to your employees, because I think everyone has now emphasized the importance of communication, and I'll echo the same thing. I definitely see a thread that's woven throughout the complaints that I'm responding to. Not that the employers are not communicating, but oftentimes it's whether it's vulnerable workers, people who aren't getting a lot of communication just by virtue of the nature of their workplace, and the reality that it's difficult to communicate now. The OSHA is telling telling many employers not to have meetings. You have meeting. One client was in the midst of an interview with OSHA, was explaining that when they have a conversation with the person in the office next to them, they do it by Zoom instead of talking to them. So how do you communicate effectively with your employees when you're not supposed to be talking to them face to face? You have to be creative. You have to rely on in many cases, besides posters, but written communication. So a plan, certainly that is translated into the languages that your workers speak as well, when that's possible, is a great idea. It's also important to keep in mind now that we're seeing a number of jurisdictions that are actually mandating adoption of these plans, whether that's at a county level, state level, or it's not been mandated obviously at the federal level, although it's certainly a recommended practice with OSHA. But for example, Puerto Rico is requiring employers that before they reopen to adopt such a plan, and employers that are open but have not developed one to adopt one as soon as possible. A number of other considerations, and I'm not going to go through each and every one of these bullet points, but a number that I think are worth talking about. And we've talked, Kara and Jordan talked about temperature checks and identifying sick employees. That's part of an overall process of when you look at how do we keep our employees safe, how do we keep sick people out of the workplace, whether that's sick customers, limiting visitors, canceling sales visits, consultants who are coming in. If it's not essential, let's delay that. But then also checking your employees, asking them the health screening questions. I've seen one client that's been testing employees' sense of smell as well, since that appears to be a potential symptom of COVID-19. So limiting your workforce, obviously requiring as many people who are not essential to what's happening in the facility, in the plant, to work from home if feasible, staggering shifts. So people, and really the primary goal there is to I think, to limit the clogging at the time clock. If everybody typically shows up at 8 o'clock and you have 200 or 300 people showing up, a number of our clients have staggered the shifts 5, 6, 7, as many as 10 shifts, 10 different start times, so there isn't the long line at the time clock. If you further on top of that, they're then adding the social distancing markers or decals on the floor leading up to the time clock. Some employers are assigning a member of management or another individual from security, for example, to enforce the social distancing protocols at areas where it's likely to have groups of employees congregating. If you do use a biometric time clock with the like a thumb scan or something like that, I would certainly encourage you to disable that function if you can. However else you might need, and this gets into the wage and hour issues that Jordan was talking about, however you're tracking time. The last thing I would want to have to explain to an OSHA investigator, if you had a cluster of 50 or 100 confirmed cases at your workplace, was that we have the time clock that every single employee touches one after another. Same thing if you have entry gates. Some companies have kind of rotating gates or that lock after each person goes through, and you have to scan through to get through that. Same thing, if everybody has to touch the same door, can you leave it open? Can you disable that security feature? As far as enhancing workplace housekeeping or cleaning, that really has kind of two primary components. both daily cleaning. So you want to have some protocol of enhanced daily cleaning of what are considered high touch areas, doorknobs, light switches, keyboards. If you have equipment that is shared amongst employees, if you're in a distribution center and people use scanners to scan pallets or things like that, if more than one person uses it in a shift, make sure you have some protocol in place that it's cleaned before and after the handoff. Same thing with forklifts. See a number of clients that have included in the pre-shift forklift inspection a checkbox, whether it's electronic or on a paper format, that the forklift is wiped down between users. And then on top of the daily inspections, we're seeing a number of companies that are doing either weekly deep cleanings themselves or bringing in a third-party professional cleaning service to do those deep cleanings. And obviously in the event of confirmed cases or a rash of confirmed cases, to perhaps even shut down the facility for some period of time, whether it's a few days or a week, for further enhanced and deep cleaning. Moving on to, I think the last slide that I'm going to cover just kind of further breaks down these protective measures to consider. The OSHA generally now analyzes most hazards in what's referred to as the hierarchy of controls. So it's kind of turning that pyramid we saw on the prior slide upside down, with the broadest level of protection being afforded by engineering controls. Before you get to that, really, obviously the goal would be to eliminate the hazard entirely, which is some of the steps you can take to eliminate the hazard entirely would be having people work from home, so they are eliminated from that. They're not either exposed within the workplace, nor are they potentially bringing the coronavirus into the workplace. For some companies, like veterinary health clinics, we're seeing curbside pickup and delivery of your animal. So you're not coming into the clinic. They're making that handoff on the sidewalk or in a parking lot. So that's one way to eliminate the hazard. When you can't eliminate the hazard, then you first look at engineering controls. So these would be measures like installing high efficiency air filters, increasing the ventilation rates. A number of our clients have done that. They're changing the filters more frequently. I think everyone's probably familiar now with the installation of physical barriers being, that's an engineering control. So for our retail clients, sneeze guards at the registers. As you kind of watch the kind of evolution of the complaints that we received, first there were a lot of complaints coming in for retail clients that my employer hasn't installed sneeze guards or plexiglass barriers. Then once they were installed, then the complaints started coming in. Well, the barriers aren't big enough. They don't provide sufficient protection. So when you're selecting the barriers and the size, you want to make sure you're considering kind of whether they are providing sufficient protection. The two most common, I think, effective and widely used protective measures would be administrative controls and safe work practices. It's difficult to really adopt a number of engineering controls to protect employees from this type of a virus. So it really comes down to administrative controls, and a few of them are listed here. Again, having a protocol in place and adopting policies that enable and enhance the ability of employees who are not feeling well, even if they don't know that they're confirmed positives, to stay home, conducting your meetings virtually, adopting telework. I've talked about the staggered shifts, job rotations, changing the way you're doing the work. And then the safe work practices are steps that you can take to reduce the frequency or intensity of an individual's potential exposure. So this would be regular hand washing, good hygiene, training on good hygiene, reminders for how to practice cough etiquette and things like that, the cleaning practices, and then last but not least, the personal protective equipment. As Eric talked about this, and Jordan too, with respect to the masks, being whether or not they are PPE, certainly they do provide levels of comfort and protection for certain jobs. I've seen manufacturing companies where they can't socially distance their employees at all workstations, and if barriers aren't feasible, that they then have been providing these plexiglass wraparound face shields and gloves. And certainly if you make sure, as it's been mentioned already, when you are providing those types of protection, that you're training the employees on how to use them safely, how to put them on, how to take them off, and do so in a way that they're not then exposing themselves to the virus.
One other thing to talk about from the PPE standpoint is it's not just PPE for protection against infection control or exposure to the virus. We are, Aaron talked about those enhanced housekeeping procedures. Perhaps we're introducing new chemicals into the workplace we haven't used before for purposes of our new housekeeping program. If that's the case, think about whether there's additional PPE requirements that may be necessary for that, or if you're engaging in those pre-work or pre-shift health screenings, temperature taking exercise. The employee, if there is an employee who is tasked with interacting with your entire workforce to screen their temperatures on the way in the building in the morning, that employee will very likely need to be provided with PPE that goes beyond a face covering that you would provide for the rest of your staff. That's an employee who probably should be in something more akin to a respirator, N95 mask, face shield, gloves, gown. All of these things listed here would be appropriate for somebody who's going to have regular, even short-term, but regular close contact with potentially infected individuals. There's PPE for that task as well.
Yeah, and I think that's a really important reminder when you put that in the enforcement context that I described a little bit ago, that while we're seeing these information and document requests, these hazard alert letters, we are starting to see now that the agency is also not just focusing on what's your exposure control plan, what is your cleaning schedule, are you taking temperature checks, but then now they're asking for, send us a copy of the safety data sheets for the chemicals that you're now using. I haven't seen one yet, but I expect that we'll start seeing them asking for, send us the PPE hazard assessments that you've conducted for these new tasks that you're performing, and send us the PPE training and things like that. So it's a little bit of a game of catch up that they're playing, and I think once they kind of get their sea legs under them, we're going to see more requests looking at those kind of secondary standards that are implicated by the way in which employers respond to the pandemic. I think with that, Eric, I'll turn it over to you.
We talked earlier already about voluntary use of respiratory protection. This slide is about the use of respiratory protection for reasons unrelated to COVID-19. If you have exposure to chemicals in your workplace or nuisance dust at a level where you have always required an N95 mask or something more substantial, and the supply of those masks is just not available anymore. That's been a worldwide experience. OSHA has introduced some guidance that would help extend the life of your existing supply of masks and make other recommendations for how you might deal with the lack of inventory of your masks. Basically, you don't have to do annual respirator fit tests with N95 masks because that's a disposable test or a destructive test, and we're trying to preserve our masks, so you don't have to do that. You can reuse respirators beyond manufacturer's recommended life or expiration dates printed on the masks, as long as you're doing a thoughtful visual inspection to make sure it's still in good condition. It's not going to fall away from your face, and the protective medium of the face piece itself is not compromised. And then finally, they are blessing the use of basically N95 equivalents that ordinarily you would not be allowed to use in the U.S. because they've not been approved by NIOSH. Because there is a shortage, they're permitting the use of certain masks qualified under similar standards in other countries, most notably the KN95 mask from China, others from Australia and the UK. So you check out that guidance if you're in need of supplementing your supply of masks and not having much luck with the NIOSH approved one, that's an option. But basically show some good faith efforts, make sure you're training employees, and you will get some relief from enforcement on traditional respiratory protection issues. On the next slide, talk about the other big one we're getting tons and tons of questions about is record keeping and reporting. There was, at the start of this outbreak, a lot of interest by industry to have OSHA sweep COVID-19 into the existing cold and flu exemption to OSHA record keeping. Right now, OSHA says cold and flu are too difficult to determine whether an exposure was at work or outside of work. And so there is a rule in the OSHA regulations that says cold and flu are exempt outright. OSHA has declined to include COVID-19 in that exemption. I understand why. That exemption is not a policy, it's a rule that's gone through notice and comment rulemaking. OSHA can't just wave a wand and say COVID-19 is the cold or flu. To bring a similar exemption, they'd have to do rulemaking. And that would take longer probably than before we would have a vaccine for the virus. So it is not exempt, but OSHA has put some pretty serious limitations on when it is recordable or reportable. The general framework is it must be a confirmed case, and confirmed case by definition in this guidance is confirmed by a test of, sort of a secretion-based test in a laboratory, not self-diagnosis, not diagnosis based on the observation of certain symptoms. Yeah, this is almost certainly COVID-19, but we're not going to bother with a test. Then it's not a confirmed case. Confirmed case means is a lab test that has shown a confirmation of the virus. It has to trigger one of the recording criteria. That's essentially always going to happen because quarantine does constitute days away. So at the very least, you'll trigger that criteria. But the third one is the big one. You must be determined to be work-related. And how in the world do you determine that this exposure happened at work instead of on the way to work or at home or at the grocery store? And OSHA acknowledges how difficult that will be. And that's why on the next slide, they gave us this wonderful guidance on April 10th that basically said, unless you are in healthcare, unless you are an emergency responder, or unless you are in running a correctional facility, you don't even need to undertake the work-relatedness analysis at all, unless work-relatedness is just slapping you in the face, totally obvious. So the concept there is if you have what they say numerous cases, what I call a cluster of cases among those that are known to be working closely together, in that circumstance, you at least need to do the individual case-by-case analysis for work-relatedness. So don't even need to look unless there's numerous cases of people known to be working together. And even when that's the case, do the analysis. And the analysis, one of the exemptions or one of the things that will kick you back out of work-relatedness is if there is evidence of any other potential explanation for the infection. And that will almost always be the case, right? How did the employee get to work? Public transportation, so they have someone in their home who works in a hospital, anyone else in the home who's tested positive? Are they the ones doing the grocery stores? If there is an alternative explanation, technically by OSHA's guidance, it would not be a work-related illness, and therefore it would not need to be recorded. And on the next slide, we'll talk about reporting. And this is another, big exemptions, big reasons that many of these cases will not be reported. One is do the same work-relatedness analysis under the same framework OSHA has just provided, and it will be very difficult to find work-relatedness in most cases. But even if you get to the point of determining work-relatedness, you're only reporting to OSHA if there's a hospitalization or a fatality. And for a hospitalization, you only report if the employee is admitted to the inpatient service of the hospital within 24 hours of the exposure at work that caused the illness. And COVID-19 just doesn't work that way. It does not move that quickly. Generally, people are not showing any symptoms at all for 24, 48, or even 72 hours. And then sometime after that, still before the symptoms become so severe that they would be hospitalized. So it is my view, I would be absolutely stunned if there is any circumstance where a COVID-19 hospitalization would ever need to be reported, because it would be, seems to me, almost impossible that the exposure occurred within 24 hours of the hospitalization. A death, on the other hand, has to be reported to OSHA if it's work-related. and it occurs within 30 days of the work-related exposure. There are instances, surely, where that is occurring more than 30 days after the exposure, but it does look like those are progressing to the point that individuals succumb to the illness, sometimes within 2-3 weeks, or a little bit more. So some of those could be reportable if you really clear that work-relatedness bar, whereas essentially no other explanation for how the employee became sick. On the last topic, I believe, is this new guidance that OSHA issued, basically an enforcement memo that OSHA issued a little bit earlier, about a little less than a month ago, basically saying to all industries, this is enforcement for things other than COVID-19, other than your response or management of COVID-19, but it's compliance obligations that you may not be able to accomplish because of the pandemic. So things like, an annual training program, your annual forklift training, or audiometric testing, or medical surveillance requirements under chemical specific standards. Those things that have recurring annual or otherwise recurring deadlines that may not be achievable either because of shutdown orders, travel restrictions, no visitor policies, or because they require some close interaction, close contact for the training event to occur, or because it would be dangerous and really foolish to carry out the exercise, like audiometric testing, marching all your employees through a small trailer to be tested on the same machine seems like a terrible idea in light of the pandemic. So for those types of regulatory requirements, if you are not able to accomplish them because of the virus or because of the pandemic, then OSHA will not be bringing enforcement actions for those issues. The next slide, we'll talk a little bit about what that means, and then I think we'll finally be able to let you go. Let's just go ahead and skip to the next slide, because this talks a little bit about, it's not just a matter of saying, hey, throwing up my hands and saying pandemic. You have to actually show OSHA that you were undertaking good faith efforts to comply sort of before, the pandemic. So you might be able to show from documentation that you had contracted with a third-party training company or a third-party healthcare or industrial hygiene service to do the audiometric testing or whatever monitoring was going to be done, and then showing by some documentation that it was canceled because of coronavirus, right? Travel restrictions, shutdown of the industrial hygiene company that was going to do the work, documenting your good faith effort to comply. And then on the next slide, additional documentation that you'll want to have is to show your good faith efforts to implement some interim control, some interim measure to deal with that same hazard. So if it's audiometric testing that you're canceling, have you made any changes to throughput or work practices that would minimize times when you were at peak volume of noise at the workplace, using the equipment less that makes a lot of noise, or just doing more frequent checks that your employees are wearing their hearing protection as they're required to do. Anything to show some good faith effort here while you wait to come back into compliance. And then of course, OSHA expects you to move as quickly as possible to get back into compliance after travel restrictions and things like that are relaxed. And then on the last slide, I think it's just a list of some examples of the types of things that may be covered by this enforcement discretion, enforcement relaxation memo. This is not an exhaustive list. This sort of describes a principle of the types of things that will be excused if they are caused by, if the non-compliance is caused by, the implications of the pandemic. And I think that is our last slide of the day. So we'll encourage everyone. Here's about us, who by now, hopefully you know well, and we're big nerds about this stuff and love talking about it. Would love to be a resource. Check out our blog. We are posting, it seems like almost every day, new content about coronavirus and the labor employment or OSHA implications. And then when we're not talking about coronavirus all the time, we've got a great webinar series on just your, what seems quaint now, run-of-the-mill labor and employment issues and OSHA issues other than this pandemic. So we encourage you to participate in those. These are free webinars just like today.
We really appreciate your attendance and your participation, and we hope you found this webinar to be useful as you are thinking about all of the things you need to take into consideration when you're coming back to work. Thanks Thanks, everybody. And don't hesitate to reach out to any of us if you've got questions after the presentation. Thanks again. Stay safe, everybody.
Thanks, everyone.